name is Gary Kibel, and I'm a partner with the law firm of Davis and Gilbert, New York. I practice mainly in the areas of new media, technology, privacy, and data security. What Joe was alluding to is that there was a settlement announced last week between the Federal Trade Commission and Facebook. The Federal Trade Commission is the federal agency that, for lack of an appropriate agency, is charged with enforcing privacy issues, sort of in a generic sense in the United States. We have agencies that enforce privacy with respect to financial services, with respect to health and medical information, but the FTC has pretty much taken on the role of enforcing privacy in general commercial settings. So the history of this is the way investigations with the FTC generally work is either the FTC has noticed something in the marketplace, or more often someone has made a complaint. In this case, there have been some complaints about Facebook's privacy practices. And then the FTC generally launches what's really a confidential investigation. It's the FTC may either voluntarily ask you to submit information about your practices, or they may subpoena records about your practices. This tends to happen somewhat in the background and quiet. At the end of this process, which can go on for a while, either the FTC will decide that there's been no violation and the matter is dropped, or they may decide that we're going to bring a complaint against the target company. At the same time, the FTC often offers up a settlement. And it's sort of, you can pick from column A or column B. They can file the complaint, or you can negotiate and sign the settlement agreement. Most companies will negotiate and sign the settlement agreement. Very few in the privacy area will go to court and fight the Federal Trade Commission. So Facebook signed a settlement with the FTC, and it covered Facebook's privacy practices and has to change their behavior going forward. The complaint that the FTC had brought against Facebook alleged a number of things. First and foremost was that Facebook had misrepresented how they were going to treat and handle personal information of their users. Most companies will make a disclosure about how information is going to be handled. That will be in a privacy policy. That will be through privacy settings. It can be through other communications. Even an on-screen display or an email to a user saying how information is going to be used can be a representation about privacy. So the FTC alleged that they had misrepresented how they would handle the information. Secondly, they also alleged that Facebook had made material changes to their policies without properly notifying the users, and that they applied those retroactively. Now, material is kind of a lawyer word. What does that mean? The FTC certainly has a big concern about consumers understanding how their information is going to be handled. And they have a very realistic understanding that most consumers don't read privacy policies. So if a consumer is given one set of expectations about how information is going to be treated, you can't completely change that by just doing a 100% revision of your privacy policy and saying, well, we've told the consumer what we're going to do, and now we're going to do something different. They really want consumers to be told front and center if things are going to change. And those changes shouldn't automatically be retroactive. You should give consumers an opportunity to opt out. Let me give you a real-life example. If you operated a website and you said in your policy, we will never share your personal information with a third party, but you decided years later that you wanted to share the information with third parties and sell your mailing list or share your contacts, you couldn't simply just change your privacy policy to allow this. You would have to tell the consumers and put something front and center. Because think about it from the consumer's point of view. Their approach may be, well, I would never have given you my information in the first place if I knew you were going to share it with third parties. And now that you're going to share it with third parties, I want the right to delete my information from your database. So those retroactive changes were a problem. Another unique Facebook issue was that when a user deleted content or even deleted their Facebook account, their content was actually still accessible online. many photos and videos had unique vanity URLs. And so even though the user had deleted it, those URLs were still accessible. Two other parts of the complaint: Facebook had a program called verified apps for a period of time. If you're familiar with Facebook, you know that there are apps from third parties that you can download and play games, or for marketers. And they had a program that Facebook administered verifying these apps for privacy and data security purposes.
Why don't we get back to that right after this commercial break, all right?
Sure.
Verified apps right after this. We'll be back with more with Gary Kibel from Davis and Gilbert here in the city. 1 second, folks. We'll be right back after this commercial.